Hello friends, my name is Amit Jyoti. I am an assistant professor at the O.P. Jindal Global University. In this module, we shall be talking about soft law as the source of international human rights law. The sources that we have discussed so far are the ones that are specifically listed under Article 38(1) of the Statute of the International Court of Justice, and those are regarded by the international scholars as the traditional or the formal sources of international law. Now, a pertinent question experienced with the formal sources is their inability to explain the status of the recently developed expressions of international law. For example, resolutions of international organizations, declarations that are issued at international forums, joint statements that are issued by nations to conclude conferences, general comments given out by the treaty bodies, guiding principles of law generated by expert bodies, among several other things. Given that the foregoing are not specifically listed out as the formal sources of international law, their contribution towards the development of human rights law in the international arena cannot be questioned. These not so formal sources of law are categorized and referred to as the soft law. Now let us discuss about the relevance of soft law in the area of human rights. The relevance of soft law has been summed up beautifully by Roberto Andomo in his article titled "The Invaluable Role of Soft Law in the Development of Universal Norms in Bioethics." He says, and I quote, "Soft law are often referred to by scholars as non-binding instruments. This characterization is not entirely wrong, but may be misleading because although soft law does not have per se binding effect, it is conceived to have such effect in the long term. This means that while treaties are actually binding after ratification by states, soft law instruments are only potentially binding. Soft law is indeed conceived as the beginning of a gradual process in which further steps are needed to make of such agreements binding rules for states. It should be noted that if the binding effect were totally absent from such instruments, then they would not be law at all. Because one of the main distinctions between ethics and law is precisely that law is made up of enforceable norms, while ethics is not enforceable. Here, the author goes on to conclude in his article, and I quote again, "This clarification is crucial because it is common to affirm that soft law just creates moral or political commitment for the states. This is only true if we consider the immediate effect of soft law. But the fact is that in more indirect and persuasive way, soft law instruments have an influence on states which is not very different from that of the treaties. We should not forget, after all, as formal intergovernmental agreements such as such instruments have a legal and not merely ethical nature. This hardening of soft law may happen in two different ways. One is when declarations are the first step towards a treaty-making process, in which reference will be made to the principles already stated in the declarations. Another possibility is that non-treaty agreements are intended to have a direct influence on the practice of states, and to the extent they are successful in doing so, they may lead to the creation of a customary law. As some experts explain, declarations may catalyze the creation of a customary law by expressing in normative terms certain principles whose general acceptance is already in the air, and thereby making it easier and more likely for states to conform their conduct to them. Now, from the above quotes, it appears that it is clear that soft law is not something that one can easily ignore. Even though they are not specifically listed out as such under the formal sources of law, by way of diplomacy, these do play a significant role in the development of human rights as a whole, at least to build a consensus at a time when states disagree to the basic tenets of law to begin with. Therefore, even though soft law as such are not legally binding, they hold immense importance in the sense of contributing towards the growth of human rights as a whole. Now, let us talk about some advantages and disadvantages of soft law. Soft law instruments have several advantages over the traditional hard law, as they are informal documents of agreement. In fact, scholars are of the opinion that soft law is a preferred method to introduce a new area of protection to various states. Let us see some of these advantages over the traditional hard law. One is that by signing or ratifying a treaty, states incur legal liability to comply with its provisions. Therefore, prior to this signing, there is a lot of negotiation at multiple levels, and accordingly, it is a time-consuming process. More so, it is very difficult to get more than 200 countries to agree to the same draft as others have proposed. Therefore, given that treaty making is a formal process, it may take its own sweet time before a treaty finally comes to being a law of the land. On the other hand, soft law in form of declarations, resolutions, general comments, guiding principles, etc. present the advantage of allowing countries to gradually become familiar with the proposed standards before they are confronted with the adoption of enforceable rules at the national or international level. This gradual procedure leaves no room for discussion, and achieving consensus on issues that are particularly complex or sensitive or exposed to change, like those related to scientific developments. Another difference is that soft law agreements do not require a formal ratification by states, and therefore they have a more direct influence on the practice of states than treaties. In this way, soft law provides a more immediate evidence of international support and consensus than a treaty whose impact may be heavily diluted by reservations and the need to wait for ratification and entry into force. Another advantage of soft law is that given its flexible nature, it allows states to adopt commitments that are suitable to a given situation. For example, when there is a great divergence in state preferences and capacity, allowing for the regime to move forward in its formation in the face of potential showstopper issues which may preclude moving forward on the larger package of problems to be addressed. Another advantage is international standards based on soft law are not only available for use by international judges, they can also be of great help in everyday interstate diplomacy. Now, one of the most highlighted disadvantage of soft law is that it is something which is not legally enforceable. To this, a lot of legal scholars have put forth the contention that enforcement of international law as a whole is questionable, and which is why it hardly matters if soft law is not officially legally unenforceable. A lot of scholars also argue that soft law is an inconsistent term because from a general and classical point of view, the rule of law is usually considered compulsory or it simply does not exist. Now let's talk about some of the General Assembly resolutions as their influence as soft law. Under the Charter of the United Nations, the General Assembly is empowered to make recommendations on various matters. Therefore, after discussing the matter, the General Assembly makes recommendations by way of issuing resolutions. The Charter of the United Nations creates a strong presumption against the legally binding character of these resolutions by designating them as recommendations alone and nothing else. This presumption becomes irrebuttable on reading part of Article 11 of the Charter, which states that any such question on which action is necessary shall be referred to the Security Council by the General Assembly either before or after the discussion. Moreover, a plain reading of Articles 10 until Article 18 of the said Charter makes it further plain and clear that the General Assembly is only tasked with making recommendations alone. If the drafters of the Charter had in any way meant to give substantial powers to the General Assembly, it is unlikely that the use of the word recommendation would have been so consistent as it is in fact in the Charter. Now, the General Assembly, being the main norm creating body of the United Nations, has since the creation of the United Nations organization been actively involved in the development of human rights norms, including the Universal Declaration of Human Rights of the year 1948, which is the most important human rights instrument. It is the most prominent resolution of the General Assembly and serves as an example of how soft law can influence hard law in its formation. Now, the UDHR lists several civil, political, economic, social and cultural rights which ought to be recognized as a common standard of achievement for all the people and all the nations, to the end that every individual and every organ of the society, keeping this declaration constantly in mind, shall strive by teaching and education to promote respect for these rights and freedoms by progressive measures, national and international, to secure their universal and effective recognition and observance. These principles were not drafted with the intention of creating legally binding obligations as such. It did not purport to be more than a statement of ideas, and at best could possibly be construed as a path-setting instrument. This, however, has changed over the years, and the present situation could be best explained in the words by saying that originally adopted only as a common standard of achievement for all peoples and all nations, the UDHR today exerts moral, political and legal influence far exceeding the intention of its drafters. The UDHR is the foundation of much of the post-1945 codification of human rights both nationally and internationally. At the national level, it has served as a model and inspiration for many constitutions, laws and policies aimed at the protection of human rights. These domestic manifestations include direct constitutional reference to the UDHR or incorporation of its provisions and reflection of its substantive articles in national legislation and judicial interpretation of domestic laws with reference to the UDHR. At the international level, most human rights treaties, both global and regional, are based on the rights originally set forth in the UDHR or at least contain a preambular reference to it. Now, this foregoing opinion on the relevance is solidified by referring to the final report of the International Law Association's Committee on the Enforcement of Human Rights on the status of UDHR in national and international law. This report noted that the UDHR remains the primary source of global human rights standards and that its recognition as a source of rights and law by states throughout the world distinguishes it from the conventional obligations. The report also noted that in some jurisdictions, the UDHR is even invoked as a source of evidence or evidence of customary international law. Additionally, given that the General Assembly has adopted n number of human rights principles and standards over these years, it is not possible to list them here. However, it is noteworthy that in recent years, the General Assembly has been actively involved in the progressive developments of human rights, particularly through the adoption of the Millennium Sustainable Development Goals. In their Millennium Declaration, the heads of state and government resolved to ensure the implementation by state parties in areas such as of international humanitarian law and human rights law, and they call upon all states to consider signing and ratifying the Rome Statute of the International Criminal Court. To conclude, it must be said that even if the General Assembly as an organ does not have the power to enforce any human rights standards in various countries, its resolutions represent state practice to some extent, and it forms a solid foundation for any future treaties that the country may sign. Now, let's look at some of the resolutions of the Security Council. In accordance with Chapter 7 of the UN Charter, the Security Council may take measures to prevent the threats to peace, breaches of peace, and acts of aggression. These measures include complete or partial interruption of economic relations and of rail, sea, air, postal, telegraphic, radio, and other means of communication, and the severance of diplomatic relations. The Security Council does in fact have the power to involve the armed forces in case it feels that the foregoing measures will not be adequate. Article 42 of the UN Charter states, should the Security Council consider that measures provided for in Article 41 would be inadequate or have proved to be inadequate, it may take such action by air, sea or land forces as may be necessary to maintain or restore international peace and security. Such actions may include demonstrations, blockade and other operations by air, sea or land forces of members of the United Nations. Now, given its power of enforcement, the United Nations Security Council has often adopted several Chapter 7 resolutions on issues concerning humanitarian assistance, thus considering humanitarian crisis and mass violations of human rights as a threat to international peace and security. It is, in fact, in this regard that resolution number 1296 of 2000 was adopted, where the Security Council stated that the committing of systematic, flagrant and widespread violations of international humanitarian law and human rights law in situations of armed conflict may constitute a threat to international peace and security, and reaffirmed its readiness to consider such situations and where necessary to adopt appropriate steps. Chapter 7 resolutions usually refer to a specific situations of massive violations of human rights and humanitarian law. In this sense, they are mainly aimed at restoring respect for international law in those situations rather than formulating rules of general application. Accordingly, the Security Council has adopted resolutions in response to certain country-specific situations where international peace and security are at risk, and frequently where armed conflict has begun or is imminent. It has, in fact, repeatedly remanded that parties to an armed conflict respect human rights and humanitarian obligations. For example, it demanded that all factions and forces in Sierra Leone respect human rights and abide by applicable rules of international humanitarian law. Concerning the situation in the Democratic Republic of Congo, it affirmed that all Congolese parties have an obligation to respect human rights and international humanitarian law, along with the security and well-being of the civilian population. It has called for full respect of human rights and international humanitarian law throughout the Afghanistan. It also called on Sudan to end the climate of impunity in Darfur by identifying and bringing to justice all those who were responsible for the widespread human rights abuses and violations of international humanitarian law. Furthermore, under the Rome Statute, the Security Council has been given a very predominant role to play in referring cases to it for alleged acts of genocide, crimes against humanity and war crimes. In fact, in accordance with Article 13 of the Rome Statute, a situation in which one or more of such crime appears to have been committed is referred to the prosecutor by the Security Council, acting under Chapter 7 of the Charter of the United Nations. The court may exercise its jurisdiction then. It is in this exercise of power that the Security Council referred to the prosecutor the Darfur situation in resolution number 1593 of the year 2005, in which it affirmed that justice and accountability were critical to achieving lasting peace and security in Darfur. To conclude, It must be said that given the enforcement measures listed out in the UN Charter, the Security Council has the central responsibility in achieving the goals of the United Nations. It is with the adoption and implementation of coercive measures that the Security Council contributes to enforcing human rights standards and international humanitarian law in general. Now, to generally comment on our discussion today in this module, I would say that as you are aware, the human rights treaty bodies are committees of independent experts that monitor the implementation of core international human rights treaties. At present, there are 10 human rights treaty bodies composed of independent experts of recognized competence in human rights who are nominated and elected for fixed renewable term of 4 years by state parties. Now, each of these treaty bodies publishes its interpretation of the provisions of its respective human rights treaty in form of general comments, or let's say in the form of general recommendations. These cover a wide range of subjects from the comprehensive interpretation of substantive provisions such as the right to life or the right to adequate food to general guidance on the information that should be submitted in state reports relating to specific articles of the treaties. These general comments and recommendations have been collated by the Office of the High Commissioner for Human Rights here. Now, these general comments and recommendations, though not legally binding in nature on the member states, however, they do sometimes play a decisive role in case for which an individual petition has been initiated. More so, these general comments are based on reasonable standards that are prevalent in international and national arena, and accordingly they do express what a wide majority of state practice is with respect to a certain issue. The guiding principles with respect to this soft law are usually written by a group of independent experts. Now, most scholars argue that in system of international human rights, where even assembly resolutions are considered soft law, how in the world do guiding principles have any place whatsoever as one of the sources of human rights law? Well, a closer look at some of the guiding principles reveals that these are well grounded in international law, and which is why judges and arbitrators do not hesitate in referring to these before taking a final call on the matter. In fact, scholars have suggested that it is possible to cite a multitude of existing legal provisions for almost every principle which provides the drafters with strong normative guidance. Furthermore, at least in certain cases, it may be more appropriate to look at standard setting more in the light of how rich body of existing more general norms should be applied to specific situation in a particular area, and to restate and expand existing law in the narrower context of a given problem. In that sense, the guiding principles may provide a model on how to promote human rights standards at a time when all basic human rights have found a sound basis in international law. Having said that, as a general rule, guiding principles do not constitute binding obligations on states. However, the circumstances of each case will decide the fate of each of these principles individually. With that, we end our discussion on this module. Thank you for listening.